Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome to Ask a Lawyer once again here on CP24. So good to have you along for the half hour. Please stick around. You're going to learn lots. My name, John Scholes, your host, and joining me very shortly, Lior Samfiru from EmploymentLawyer.ca. Right off the top, he'll tell you how you can contact Lior on the other side of the show anytime. Phone number 1-855-821-5900. Ask at EmploymentLawyer.ca. And a website I know Lior uses a couple times during the show, at least over the 30 minutes, is PocketEmploymentLawyer.ca as well. More details on that and how to use it coming up in just a bit. We'll get to some phone calls from our long-running radio shows, which you can catch locally here in the GTA, Sundays, 1 p.m. on News Talk 1010. We're going to get to human rights in the workplace. Human rights violations in the workplace, a really important topic, even now in this day and age. So we'll get to that with Lior in a bit. But, pal, we always start off with the week that was. Case of the day, Lior, what's happening in your world?
Hey, John, great to be here, of course, to talk about the rights that people don't even know they have. That's what employment law is all about. There's a lot of misconceptions, a lot of half-truths, a lot of falsehoods, frankly, when it comes to employment law, but not on this show. On this show, we tell you what you need to know. We tell you about those rights that you didn't even realize were there for you, but they are. You will learn what to do if you lost your job. You'll learn what to do if your boss is mistreating you. You'll learn what to do if you're being discriminated against or bullied, harassed. We talk about these things all the time because, as I say, it's not always going to be perfect situations in the workplace. Sometimes there's going to be conflict and problems, but by knowing your rights, you'll know what to do. You'll know what the law does. It will be less stressful for you. That's why it's so important that we spread the word out on employment law. And as you learn things on this show, tell others as well. Tell your friends, tell your family, so that they understand what their rights are. And of course, beyond this 30-minute show, if you want to talk more about your specific situation, or if what we say today raises some other questions that you have, of course, I want you and encourage you to reach out to myself and my team in the office. You'll see that contact information throughout the show, so don't be bashful. Let's have that very, very important discussion. But to start us off, as always, a case that came across my desk very recently. I spoke with a lady that worked for a real estate broker doing some administrative duties, been doing that for almost 10 years. And recently her boss told her, well, this time of year, at the end of the year, things are a bit slower, so we're going to have to put you on a temporary layoff. It's slow time of year, and we'll call you back at some point after the first of the year to continue employment. Now, interestingly, for the 10 years that she has worked for this employer, she had never been put on a temporary layoff. Now, she does acknowledge that business is slower kind of in the latter part of the year, but despite that, she always worked, she always had work, she was never put on a layoff. So this was, of course, a big shock for her. So she called me, and her simple question to me was, is this legal? Well, the answer here is an emphatic no. It is not legal. In the vast majority of cases, your employer does not have a right to put you on a temporary layoff. Even if business is slower, even if they have a legitimate reason, it's still not legal. So by putting you on a temporary layoff, you, the employee, now have the right to consider that a termination, constructive dismissal. You don't have to, of course. You can accept it and wait at home to see if they call you back. But you can also say no. By putting me on this temporary layoff, I'm treating this as a termination. Now you have to pay me my full severance. For her, that means right around 12 months of pay. And that's exactly what she decided she wanted to do. Because what I told her is if she accepts this temporary layoff and comes back in the new year, she's given her employer the right to do it again. And she does not want that. Doesn't want to be working at the whim of her employer. So she's going to get her severance. I'm going to help her. But an important lesson for you, regardless of what job you're in or what industry, unless you've been laid off before and accepted it, If you're put on a temporary layoff, you can treat that as a termination and get your severance. If that's your situation and that's what you want to do, you call me.
It's smart of her to nip this one in the bud, Lior, because unlike some construction work like roofing or pool cleaners, for years you and I have chuckled at that one, where it's automatic. You assume that there's some sort of layoff due to seasonal work, right?
So some jobs are inherently seasonal, as you say, roofers, pool cleaners, etc. So by definition, it's assumed and understood that you're not going to work in the slow season. You're going to be put off work on a layoff and come back. And that's fine, because that's the nature of the job. For her, that wasn't. For 10 years, there's been no issue. She worked continuously year-round. So there's no basis, no legal basis for the company to say that they have to do this. That's something she can treat as a termination, and that would be true for most people.
All right, as mentioned off the top, radio shows across the country. We've been hosting those for years, locally right here. News Talk 1010, Sundays at 1 p.m. We'd like to get some of the phone calls playing back here, Lior. Talk about them a bit. Here's the first phone call for this half hour. Go ahead.
I was a subcontractor for 11 years, a heating contractor. They didn't take taxes off our check, but they did supply us with parts. They supplied us with our work. And one day I was fired out of the blue with no reason really given to me whatsoever. I didn't receive any severances. At the same time, 3 or 4 other guys were fired. They did get severance.
How old are you?
I'm 35. I was on about 80 grand a year.
So this is a common situation, and it raises the question, is this person a true contractor, or is he really an employee that's been misclassified as a contractor? Based on what he had described, that he essentially had a regular job, company told him what to do, they gave him the equipment to do the job, etc. He is an employee. Very common situation when someone has been misclassified as a contractor, but the law considers them to be an employee. Remember, it doesn't matter what you think you are, what the company you work for thinks you are, doesn't matter what you signed or even how you pay your taxes. At the end of the day, if you look like an employee and act like an employee, you're an employee. And why is that so important? Well, it's important because if he's really an employee and now he lost his job, he's entitled to severance like an employee. He may not have gotten a severance if he was truly a contractor, but because he's an employee that's been misclassified, severance has to be paid. So the last question that we need to answer, of course, is how much severance? For that, we're going to go back to our handy tool, the severance calculator. You can find that, of course, at pocketemploymentlawyer.ca. It's free and anonymous, and we're going to use that right now to see how much severance this person is owed. He's really an employee. As a heating contractor, worked there for 11 years, 35 years of age. We can see that he's actually owed 9 to 12 months of severance. Right around that 12-month severance mark is what I would assess him at. So a year's pay, even though the company says he is a contractor. That's why it's so important that you understand your rights, understand when you've been misclassified, understand when severance is owed to you. And of course, I'm here to help if you're not sure what you're owed or how to get it.
All right, Lior, good stuff. We're all warmed up. We're going to take a short break. Human rights violations in the workplace. That is our next stop. As we mentioned off the top, we'll get to that as we continue right here on Ask a Lawyer on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, thank you so much for hanging through that break. We are back here on Ask a Lawyer on CP24. To reach out to Lior anytime, make that phone call, 1-855-821-5900. You can scan that QR code as well and email ask@employmentlawyer.ca. Important topic this week, Lior. Well, every week they're important, but this one much so, as it is human rights violations in the workplace. Start off with, brass tacks, right down to the basics. What is a human right, and, how are they protected in the workplace?
Yeah, so there's some misconception as to what really is a human right. Some people think that the term just means any right that you have as a person. Well, not necessarily. So that, generally speaking, human rights, what we refer to that is the fact that we all have a right not to be mistreated, treated differently, or discriminated against based on certain prohibited grounds. Okay, so for example, there's a list of prohibited grounds that includes our race, gender, age, ethnicity, disability. So every province enacted legislation. In Ontario, we have the Ontario Human Rights Code that says you cannot be discriminated or mistreated or even treated differently because of those grounds. You can't be discriminated based on your age or your ethnicity, etc. So if something happens to you because of those grounds, because of one of those grounds or more, then that means your human rights have been violated. That's a very big deal, and there's penalties, and there's fines, and there's damages that have to be paid in situations where someone breaches your human rights, and it's certainly that applies in the workplace, meaning your employer can't discriminate, mistreat you, or treat you differently based on one of those prohibited grounds.
As far as the workplace is concerned in that setting, Lior, what are some common examples?
So there are many. An example may be a situation where your employer lets you go because of your age. Let's say you cannot be discriminated against based on your age. So if your employer says that, well, we're not going to keep you employed, you're not going to hire you, or we're going to let you go because of your age, well, that's not something an employer can do. That's a common thing. That's a human rights violation. Another is with respect to someone's religious beliefs, for example. You can't be discriminated based on those. Your employer, in fact, may have to accommodate you. Another common example may be a situation where there's a maternity leave here. You can't be punished because of that. You have to be allowed to take that maternity leave because that's a prohibited ground. Finally, one that I see often is with respect to a disability. You cannot be discriminated against, refused work, or fired because you have a serious medical condition. And in fact, if you need help and support, what we call accommodation, your employer has to accommodate you if you need that because of your medical condition.
You know, you mentioned that word accommodation. It comes up quite often on the show, Lior. When, from an employer standpoint, when's it too much?
So what the law says, what our Human Rights Code says very clearly, is that if an employee needs some help because of their medical condition, they need maybe modified hours, modified duties, maybe the ability to work from home, and if that's supported by a doctor's note, well, the employer has to provide that accommodation. They have to, even if it's difficult, okay? Even if it's a situation where the company says, well, it's going to cost us some money to provide these modified duties, well, the law says very clearly, well, you still have to do it. So difficult is not a good enough reason not to do it. Now, of course, at some point, it becomes too hard. We call this undue hardship. So what that means is if it's so difficult or so expensive, so complicated to provide accommodation that you really can't practically do it, that's when an employer can say, no, I'm not going to do it. But John, in my experience, most employers say it's too hard or too complicated before it actually is so. So if your employer is not accommodating you when they should be accommodating you, well, that's a human rights violation. That could also result in a constructive dismissal. It's illegal, and there's going to be significant consequences under human rights legislation.
So if an employee feels that maybe one or more of their human rights have been violated from the aforementioned list that you went through earlier, what do they do? What's the first step?
Well, a good place to start is let's talk. Give me a call, give my team a call. We'll find out a lot about what happened and whether or not what you're describing constitutes a human rights violation. By the way, we have another tool in place at EmploymentLawyer.ca that allows you to find out if your situation is a human rights violation. Of course, you may also want to talk to your employer or your HR manager to see, to make sure that they understand what's happening there. They may be able to help you. But ultimately, if you can't resolve something internally, if you feel you've been mistreated, maybe now you've been let go and you think it has to do with your age or your disability or race, etc., you call me. There's various options that we have through our human rights system as well as the court system, and the law is on your side when it comes to these things. No company should ever be allowed to get away with a human rights violation.
If you travel over to EmploymentLawyer.ca, you'll find the media page and find a radio station in your jurisdiction where you can find Lior and I's show. Probably almost guaranteed across the country, but locally here, as I mentioned, News Talk 1010, Sundays at 1 p.m. We play the phone calls back here, Lior. We talk about them. Phone call number 2 is coming at you right now.
My wife works for a company. She's been there for about 2 years. She does it very well. She's received many emails from the employer to say you're doing a fantastic job, essentially telling her she's got a job for life. I love what you're doing. She's even gotten awards. The employer recently had someone come in. She is an efficiency expert. So today, the entire department, which consists of 2 people, my wife and her supervisor, were told by the boss, I want to know what you're doing every 15 minutes. Can they do that?
Well, it doesn't sound very efficient, does it? So here's the thing. Here's what I'm going to say about that. An employer is entitled to get some information, and as long as they're not doing this in the long term, they can require you to report more regularly and to, of course, tell them exactly what you're doing as they're gathering information to understand if the role is done properly, if there's things that can be done better. So that's reasonable. But when it becomes illegal is for your employer to make these big changes that now moving forward, you always have to report every 15 minutes. You can't really do your job. And now your job is very different than when it was. So if it becomes a permanent thing and now you're looking at very different responsibilities, that could be a constructive dismissal. So if it's a short-term thing, fine. If it becomes to the point where now you're very stressed, maybe it's now become a form of harassment, because you're just not allowed to do your job, that's crossing a line. That's not legal. So I would say to this person, give it a bit of time. Give it a couple of weeks, see where things are. And if it continues beyond that, it may be time to say, well, wait a second, this is unreasonable. That's not what I signed up for. That's a constructive dismissal. I'm not going to take it. I'm going to move on and get my severance.
The phone calls always come in threes on this show. The third one's coming up after a break. This is Ask a Lawyer on CP24. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer. This is CP24. 3 phone calls every show. That's how we work from our radio show. You can find one. Go to EmploymentLawyer.ca and News Talk 1010 right here in the GTA, Sundays at 1 p.m. You can join Lior and myself. Okay, Lior, let's get to that third phone call. Let's have a listen.
I was hired to work for a company temporarily at the beginning, and then I was hired full-time. And after all total about a year and 3 months, I've been offered to stay home for a bit until work comes or take a layoff. And I chose a layoff to look for another job. And the only thing I got paid is my vacation pay. And I just wondered, what I supposed to get paid more?
So this is a very simple question to answer, and that is this. Regardless of how the layoff happened, whether it's something that you were given an option or the company did unilaterally, if you lose your job, you are owed severance. And it's easy to think that this person, just because they worked for a year and a half, maybe doesn't get anything or maybe get something very, very little. No, that's nonsense. That is not true. He is owed severance. Doesn't matter if you call him a temporary worker. Doesn't matter if he's full-time, part-time, year and a half. He is absolutely owed severance. I'm going to show you how much severance he's owed even after a year and a half. We're going to go back to our severance calculator tool. You'll find that, of course, at pocketemploymentlawyer.ca. And now we're going to see exactly how much severance this person is owed. We know he's in a sales role at the age of 44. He's only been there for a year and a half, not a very long time. But as you see there at the bottom in yellow, he is owed 3 to 5 months of severance, not days, not even weeks, months severance. And by the way, that's how it works with short service employees. Even a short service employee like this person, a year and a half, is owed months of severance. So if you lose your job, doesn't matter to me if you work for a month or 35 years, call me if you lose that job.
We have time for an email now, Lior. Ask at EmploymentLawyer.ca is how you send one along. And here's how we're going to make this work. It goes like this. I just lost my job as a senior manager at a telecom company after 2 years. My severance is only a few weeks. Shouldn't my 15 years of service at my previous company count for more? Someone's watched the show before.
Someone has, absolutely. And I'm glad. Now, if this person was recruited away from another job, okay, then that 15 years would count. So even though she's only had 2 years with this company, if she was recruited from another company, in other words, she didn't apply, she didn't knock on the company's door, they came to her and took her away, they induced her, well, then she's now really a 17-year employee, means she should be getting severance like a 17-year employee. And that could be many, many months. It could be as much as 2 years of pay. But here's the thing. Even if she's only a 2-year employee, even then her severance is not just a few weeks. Even if she's really only a 2-year employee, that severance could easily be several months, even 6 months of severance. So again, don't assume that you don't get credit for your past time. And also, of course, don't assume that just because you work somewhere for a short period of time, your severance is small. That's not the case. Go to pocketemploymentlawyer.ca or give me a call and let's talk about it.
All right, we got time for another question from your live stream on the other side of the break, Lior, so we'll take care of that after a short break. This is Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back. Ask a Lawyer here on CP24. We encourage you to join Lior weekly on his Facebook and YouTube live streams. Go to stlawyers.ca. Here's a question for this week. Lior says, my wife suffers from severe depression, which keeps her from working. She was denied long-term disability a few months ago, despite having support from 2 different doctors. She's appealing the decision, but we're worried about the outcome. Her boss is also growing impatient. What do you think?
So remember, the insurance company doesn't want to have to pay you. The insurance company wants you to be off their books. So appealing the decision to the insurance company is a waste of time. You're appealing to the people that have already decided and they don't really want to approve you. That's why we have a whole team at the firm dealing exclusively with these issues. They'll get you the benefits you need and get the compensation that you're actually owed. So let us deal with the insurance company, take that headache off you. And of course, as relates to your employer, as long as you have a doctor's note, that's all you need to be off work. Your employer can't do anything to you in that situation. Get that doctor's note and let us deal with that insurance company.
And we are up against the clock. We got a lot in there, but we got to fly. Lior, thank you so much for tuning in as well. I'll tell you how to reach Lior and his team anytime between shows. Going forward, you always can. That number is 1-855-821-5900. Ask at EmploymentLawyer.ca, pocketemploymentlawyer.ca, and of course, News Talk 1010 locally to catch our radio show. And for any other concerns, cp24.com/askalawyer, and we'll catch you next time. Thank you so much.